Yes, I'm ready.
Mr. Adams? All right. So we're set on the 22nd, 29th? 29th. Any pretrial issues?
State's going to file a noticing one additional witness. It's already contained the discovery of Dr. Villarreal. Anticipating calling him as a fact witness because he was a treating physician in the ER. I'm filing that today. He was working on it, time ran away from me, but that's it from us. Other than that, we have there's a motion from the defense to adopt all pleadings into the new injury to an elderly case. We have no objection to that. I think that's the simplest way to go about everything. We would request that our motions are adopted as well.
I think I've already signed your order on that, and granted reciprocal. Everybody's motions moved over. Anything from the... Sorry. It's a lot easier to do it this way. Anything from the defense?
Yes, Your Honor. I don't know, because of some issues that we had yesterday afternoon with e-file, I don't know if the court has or the state has the motion for continuance that I filed yesterday afternoon in the injury to an elderly person. It's my understanding that the state intends to file a motion to dismiss the manslaughter charge. That's what Mr. Mickelson represents in December.
Yeah, the idea is that the injury to an elderly takes the place of the manslaughter. We're not seeking to have multiple cases against them. It's the same one.
So I'm assuming that we're here on pretrial for the injury to an elderly person case?
I agree with that.
And not the manslaughter case?
Yes.
Okay. So my motion for continuance was filed in the new case, the most recently indicted injury to an elderly person case. That indictment was handed down on December 21st. I was out of the office on vacation. Maybe I shouldn't have taken so much time off for Christmas and New Year's Eve break, but I was essentially away from work from December 23 and back at work on January 2. Then we had this week with MLK Day and the inclement weather day. Essentially, I've had 15 days in the office since the day that the new indictment was filed to prepare for it. In addition to that, I request, the court I'm sure knows, I requested a copy of the trial transcript from our last trial. I received that on Tuesday, and that's in 3 volumes, and I have not yet had time to complete my review of that. My motion for continuance is based on essentially those 2 factors. One, that we're here for a case that was indicted about a month ago, and 2, I've just received a tool that I believe is essential to me in my defense of Mr. Thompson for what's essentially going to be a retrial. 3, I just noticed after I filed my motion for continuance, the state's request for a subpoena of Dr. Villarreal, if I'm pronouncing that correctly. Of course, he's been identified in the discovery, but the fact that he's been designated as a potential fact witness in my case is a new development. The context or the elements of injury to an elderly person, and I'm sure the court is aware, I feel like I should point out to the record there's also a second count of tampering with physical evidence in this new indictment. The elements for those allegations are not the same as they are for manslaughter. And with the facts we have present in our case, I have not yet completed my research into all potential defenses, what's going to hold water, what's not going to work, and I need more time to do that. I think I've established everything that I need to under Article 29 of the Code of Criminal Procedure for good cause, and I'm asking the court to give us at least 60 days reset for our trial date.
Well, and I certainly appreciate why you would be making that request. Court, though, is cognizant of the fact that the underlying circumstances of this case are old. The case that was originally tried had been pending for quite some time. The facts that are alleged as the basis for this new indictment are identical not only to the facts that everybody's been aware of. This isn't newly discovered information. everybody's been aware of them for several years, but they're essentially the facts that we did litigate in the prior proceeding. I know, Mr. Adams, you said the transcript is 3 volumes. 1 volume of that is voir dire, which is probably not applicable to any.
I would disagree there. There's good information for me to use in reviewing my voir dire from the original trial. So I would disagree with the court's characterization of that volume as unnecessary or irrelevant.
All right, assuming that it is highly relevant, assuming that all 3 volumes are highly relevant, and the court, based on its own experience, having sat through the first trial, is fully aware that transcript is something that could be gone through in detail in half a day and outlined and any issues noted. I don't think it doesn't take 60 days to go through that 3-volume trial that we had. And then as far as the new witness, it was a witness who has been part of the discovery, again, for several years now. There's no surprise that this witness could have been a witness in the last trial, maybe a witness here. I think the competing interest of getting a resolution in this matter outweighs the need for any continuance on the part of the defense at this point, and so the court would deny that continuance. Anything else? All right.
I would be excused.
Yes, sir. Thank you.